Richard Schmidt, Chairman of the Municipal Code Enforcement Board. The dead mic?
No, it works.
The July 10th, 2019 meeting of the Municipal Code Enforcement Board is called to order. Please stand for the Pledge of Allegiance. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by this quasi-judicial board will be based on the evidence and facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violation. The respondents will then present his or her case. Both parties will have an opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak will be given an opportunity to do so by the chair and must address the board from the podium after giving their names and address. Upon request, copies of materials submitted by the staff are available for review. Board members are reminded to obtain permission to speak from the chair, and questions of the city should be directed to the city attorney, to the attorney for the city. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the city clerk.
Please raise your right hand. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
Cases will be taken out of order to accommodate respondents and witnesses present at the meeting tonight. Everyone has received the minutes for the last meeting and had a chance to review any changes. There being none, I call for a motion.
So moved.
Second.
Motion by Mr. Glorlich and a second by Mr. Napke. All in favor?
Aye.
Opposed? Nay, no nays. We're going to hear an unfinished business. Oh, yes, well, our ex parte communications.
Good evening, members of the board. If any of you have had any type of ex parte communications, if you can go ahead and disclose those. If you had verbal communications, if you could disclose the nature of those communications and with whom, where they occurred and when they occurred. And if you've had any written ex parte communications, if you could please disclose the nature of those written communications and then provide a copy for the clerk so that they can be placed in the record.
I've had none.
I've had none.
I've had none.
I've had none.
None.
Thank you.
So the first case we'll hear is on unfinished business, case number 19-1067. And just a note for the record that the correct compliance deadline, it's not June 12th and 13th. It is July 10th and July 11th. Just a note for the record. So case number 19-1067, City versus BN Empire LLC for property located at 11001 203 North 56th Street. The extended deadline for compliance is tonight at midnight. Officer Smith has an update.
Good evening, Mr. Chairman and board members. Lori Smith, Code Compliance Officer. I was notified today by the Community Development of a stop work order list. And I wanted to provide the board with an update. Since the last meeting, the plans have been submitted to the city for plan review and a permit. On May the 3rd, 2019, the total charges for the city were $639.50. The applicant paid $150 of that balance at that time, leaving an outstanding balance of $489.50. Since the permit hasn't been paid, the site still remains out of compliance. Mr. Ball is here in the courtroom and would like to address the board.
Okay, thank you.
Hello, Board. My name is Raj Ball. I'm at 10915 North 56th Street,
Turn your
Temple.
mic up just a bit. There you go.
Temple Terrace, Florida 33617. Hi again. We had, so I was in compliance for till about, after about a week and a half after our last board meeting. And this morning, I got a call from my contractor saying that, hey, there's some fees which are still due. So I have this blueprint with the stamp, and they've presented it to me, and I've had it, no issues whatsoever. This morning, I got a phone call and said that there are some fees which are still due. So my contractor called me. I, of course, called the code enforcer and said, what's going on? And they said, well, there's some, I'll find out. She found out. There's some more fees which are due. I called up my contractor, and I said, hey, on your bill, you always put the fees, and you know how much Temple Terrace charges. They charge $150. That's what's on my invoice. It's already done. Because, yes, they are done. So I'm not really sure what these fees are. So, and this isn't the first time I got a permit from Temple Terrace. I've always paid $150. I have looked at just now, right now, exactly at what the fees are. There's a planning review fee for $150, which they said that was paid, a permit fee, which is $125, which, again, I'm thinking, I guess I have to pay. I've never paid it before. Like I said, we've always paid $150. There's a violation fee of $350 for a stop work order, and then there's all these other $2, $8, and whatever fees. And that is why I'm out of compliance, because this morning is when I was notified of this. I'm here to ask the board to look over these fees, and one of the fees that I am asking is the $350 fee. I think it's $350. It's $350 for the stop work order. The stop work order was initially put on to my tenant when it was put on. She literally just ripped it off and kept working. I was not notified. When I was notified is when she got a second notice. And then I was notified at the same time that, hey, your tenant is not in compliance. At that time, I basically just took over. I got myself a contractor, paid him all the money, got myself blueprints, paid all the money, started coming to this, trying to get everything done by myself. Have not charged the tenant yet because I'll charge him later after I find out what I have paid. So I went above and beyond to do that, and I just hoping that the board would kind of look at the fees and see what is reasonable and let me kind of discount that for the situation that it was on.
Okay, my understanding would be that there is a stop work order fine. I'm surprised that you weren't aware of it or your contractor wasn't made aware of it with the,
Exactly.
when they picked up the plans, but.
Or when they submitted
that-
the plans.
That being on the side, I don't believe, and I have more input along here as board members, but I don't believe that we can make those decisions. That is with the planning people, the plans review and Mr. Anisi and his people as to what the fines are. The fines are not just because it was you. The fines are based on what is normal for these violations, or what, having a stop work order and then whatever else. We don't know what the charges are, so.
There's a fee there for, one of them is a permit fee, which is just a standard fee.
Right.
So that's 125 of the 489. And then the other, the stop work order is also a fee because they had to issue a stop work order. So, and again, I don't think it's, I agree with you, I don't think it's our purview at this particular time to be able to reduce or waive any of those fees. That would be something you'd have to go back and approach the building department on. And if they see fit, they can do what they do. I don't even know if they can, once they, I think it's a standard set of fees, so I'm not so sure that they can or could or would reduce those fees.
Yeah, and like I had to ask my contractor as well, I'm like, I mean, you do know about what kind of fees the standard fees are, so I'm still shocked that the contractor that's deal with you guys so many times, and I've dealt with you, that he didn't put like $275, because there was a planning fee of $150 plus $125
Well, I
permit fee.
mean, here's the way I look at it is, okay, he should have known, and maybe he didn't have to pay those in the past, but they are standard fees, so if he did know, you'd be paying them anyway.
Right.
So it's not, you're just paying them now instead of earlier. So it's not, yes, sir?
Just like to add something, if okay?
Sure.
If I could just help you out a little. Tom Baroni, Code Compliance. I had a dialogue with Amir Anisi late this afternoon. He felt as though that there was intent of bypassing the payment fee. So they went up the stairs to the second floor, got the permit. However, they're supposed to go down to the customer service and pay for the permit, and it was $600 and something. The contractor never stopped at that window, and he felt as though there was intent to not pay the fee. The $350 that this gentleman's talking about, that's correct, and Amir is firm that that's gonna stick.
Okay.
He wants that to stay, and he wants the clock to start midnight tonight. This gentleman's gonna request an additional 30 days. I think after 2 months of listening to this is just a building permit, and we waited over 2 months for this. I think and we need to move forward with this. So that's my comment.
Well, I think we can give him till noon tomorrow, but he's got to pay it. He can't pay it tonight. He can't pay it now.
No, but he had the 30 days.
Yeah.
The time that he requested, and we gave him 30 days, and now all of a sudden, today, we're here.
I think noon tomorrow is probably a
Well,
better time.
I'm fine with that, too. I mean,
Yeah.
if he comes in tomorrow, well, I'm fine with that.
Yeah, okay.
Excuse me, I also have a list of the fees, if any of the board members would like to see.
That's fine. I mean, we trust that the.
We're good. I think you want to accept it? We can,
That's fine, yeah, that's fine.
without objection, the evidence will be admitted into the record.
Thank you.
Can I make one more comment?
Okay?
Just respectfully, the contractor did pay the $150, but that was the planning thing. So it wasn't an intent to bypass it.
Mm.
When we picked up the permit, I had a stamped permit. I called twice the department and said, your department? And I said, am I in compliance? Is there anything else that I need to do? I was told, no, I was not. This morning is when I got notified about the fees. So the intent was always there to always pay.
Okay. Okay. Mr. Napke?
Question for attorney, or to the city attorney. Do we have any say really in this fee issue at all?
You're not the ones,
We're not the one that assessed it.
Pam Shoshone, city attorney. You're not the board that imposed the fee or the fine in the first place. If it was something that you had imposed, then you would have the jurisdiction, the authority to reduce your own imposition of fee, but not on this one. Not the
Thank you.
350, if that's what we're talking about.
Thank you.
And I was just gonna concur, it's not within the authority that is in the city code. It is
Right.
only the fines that you would have assessed pursuant to chapter 162 and your city code.
Thank you for the clarification. Mr. Napke?
Just a second question. When was the building permit that he referenced issued? When did they pick it up?
The only date that I know that I have is when the planning review was done, which was May the 3rd. As I've said on the paper, I went to community development today and tried to find that information. That was all I was able to get from the department, sir.
I'm looking for What he says is stamped where the contractor paid the 150. What day was that? Does anybody know?
When the date that the contractor had dropped in, I think was May, is when he paid the 150.
Okay,
And then about a week after our last meeting at the board is when we actually picked up the final, and it was dropped to me.
and what you're saying, okay, so you got about a 3-week time period in there. Today, you got this phone call.
Yes, and after I got that, I followed up and said, is there anything else, because I don't want to come to the board meeting again.
Yeah.
Because I've been coming for 2 months and I really don't, there's no reason I should have everything done. Is there anything else? And I was told, no, we're good. Don't worry about it, we're good. And this morning, my contractor got a phone call from Amir's office. It wasn't from Amir, but it was someone. And then my contractor called me and said, there's some fees that are still owed and you still need to pay them. Then I called Code Enforce, and then they went out and found out, yes, there are fees, and which I was like, okay.
But you've seen the paper that shows what the fees are, so this isn't a made-up thing. It's a real paper.
Yes,
You
yes,
know,
yes.
the
I did.
lack is probably in the communications between when you called and when the paper was
Yes.
put together. I have no idea, but if you want to accept that as an
Can I-
excuse, we'll use it. But I think that that paper really stands by itself as far as and it's out of our jurisdiction. So
Whose jurisdiction would that be in?
Building
that would be
department.
back in the building department.
Okay, so it's just Amir who
Yeah.
can do it, there's no one else that I
Yeah.
can appeal to?
Right.
Okay.
Okay?
Yep.
Thank
Looking
you.
for a motion of any kind?
We need to make a motion.
We do
for-
too, okay. I'm sorry, did you want to?
Yeah, would extending the deadline for the violation, for a few days, would that be helpful to you, to give you time to
Not
negotiate?
if I can't
or-
appeal it. If I can't appeal it and I have to pay it no matter what, then I'll just pay it tomorrow morning.
Well, all that we can do is say that your fines that you're going to be assessed are going to be assessed, and they will continue tonight, just as when you came before us 3 months ago, 2
Yeah,
months ago,
I think
seems
so.
like 3, this is probably
does.
4, that we were giving you more time to get your paperwork in order. And so all we can do tonight is give you some time. I don't know what other option
No,
we
no,
have.
that's what, the motion I was going to make is that we extend the deadline until noon tomorrow. He said he's going to go down there tomorrow morning and pay for it. We give it till noon tomorrow.
Yeah, it's not a
That makes the building department happy, that makes code department happy. May not make you happy, but like I said, I think these are dollars that you would have ultimately paid sooner anyway. They're not, it may be a surprise to you, but it's dollars that you would have incurred anyway. It's not something that you could have avoided, so.
I agree, except for the stop work
Except for the
order.
stop work order,
Yeah,
yeah.
I agree with
So,
the rest of it.
so my motion is we give him until noon tomorrow, extend the violation date until noon tomorrow, and that's the motion.
Do we have a second?
I second.
We have a motion and a second. Any discussion? There being none, call for a vote. All in favor?
Aye.
Opposed, nay? No nays. No problem. You're
Now
here,
we'll
that's-
go to the first case on the agenda. Case number 191430, City versus Omajan Shahina Satter for the property located at 8605 Shirley Drive. Cases before the board based on alleged violation of 12-860 inoperative vehicles, outdoor storage equipment. The case will be prosecuted this evening by Officer Jose Silva. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, board members. Jose Silva, Co-Compliance Officer. This case originated March 13, 2019. My inspection at the time noted two vehicles in the driveway, the residence, one with an expired tag, the other one had no tag and a flat tire. Fascia of the residence was also dirty. I left door hangers with a compliance date of March 18, 2019. My inspection on March 18, 2019 found no change, so I completed a notice of violation with a compliance date of April 2nd, 2019. That time, I conducted service on the tenant at the residence and mailed copies both certified and first-class mail to the owner of the residence. I inspected the property again on April 6, 2019, and found the property in compliance, so I closed the case. On May 24, 2019, I noticed both vehicles in the driveway of the residence with flat tires. Since the violation occurred within 45 days, I set it for the MCB hearing. This time I have two photographic to submit at this time of the inoperative vehicles in the driveway. One is dated May 24, 2019, shows the vehicle with flat tire. The second one is dated June 26, 2019, vehicles again with flat tires.
Without objection, the evidence will be admitted into the record.
Thank you.
As of this morning, the property has come into compliance. I'd like to submit an affidavit of compliance.
Without objection, the evidence will be admitted into the record.
Thank you.
And all I'm asking is for findings.
Are there any questions? Call for a motion.
Waiting for-
I think I'm ready.
Good.
All righty. Let me see if they can hear me. In case number 19-1430, I move that the city has proven by a greater weight of evidence the following violations of the City of Temple Terrace City Code did exist on a property located at 8605 Shirley Drive, Code Section 12-860. This motion is based on the sworn testimony this board has received from the code enforcement officer, Jose Silva, along with any other evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second.
Second by Mr. Napke. Any discussion? There being none, all in favor?
Aye.
Opposed? Nay, no nays.
Next case will be case number, repeat case number 191924, City versus Craig Bernstein for the property located at 418 Ferncliff Avenue. The case is before the board based on alleged violation of Section 12901, Pool's duty to maintain. Case will be prosecuted this evening by Officer Silva. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, board members. Jose Silva, Code Compliance Officer. This is a repeat of a repeat violation. The case was presented to the MCEB on September 14, 2016, MCEB 16-1752. Case was presented by Officer Scarozzo for dirty and unsanitary pool. Respondent was found guilty at that time and assessed $750 lump fine and $50 a day daily fine until the violation was corrected. On April 2nd, 2018, the violation was corrected and the property brought into compliance. On April 10th, 2019, Director Brony received a photograph by text from Mr. Cartwright, who lives behind the residence, of the unsanitary pool contents. Responded to the residence and left a door hanger with a compliance date of May 4th, 2019. My inspection on May 2nd, 2019 revealed no change, so I completed a repeat violation. No one was home, so I posted a notice at the front door of the residence as well as City Hall. Also mailed copies, both certified and regular mail, to the address of the registered owner. This time, I'd like to submit 3 pieces of evidence. First is going to be the notice photograph is going to be posted at the front door. Second is going to be with the pool with unsanitary water, and a copy of the MCB order from September 14, 2016.
Without objection, the evidence will be admitted into the record.
Thank you.
There is a 6-foot-high privacy fence around the property, so the pool is secure. And as of this morning, it's still out of compliance.
You said this is a repeat of a repeat?
Yes, sir.
Okay, to make sure. All right, thank you.
Was the picture taken from the neighbor's?
The driveway, then they run straight next to his property. That was taken from Ms. Waddell's driveway. The neighbor.
Is the pool being cared for, or is it green? Because you can't tell by the picture if the pool's green or not.
It's green.
It's green, okay. I can't tell.
Mr. Sean?
Have you had any dialogue with the owner?
Only last year, Director Baroni and I went to the house and met Mr. Brunstein as he was exiting and asked him to correct the problems, and he immediately complied. That's why that other lien stopped on the house.
Okay. And what were the dates that it was noticed that it was the out of violation starting the repeat?
We're starting the repeat without violation would be from May 12th, 2019 to tonight. It's 59 days.
Okay. Thank you.
Yes, sir, the boat's been gone. It comes and goes.
Is this something that you don't normally notice from the street, or you have to be, you rely on the neighbor to complain, or is that?
Mr. Cartwright lives behind the residence. Mr. Cartwright's the one that texts Director Baroni a photograph of the pool. You actually have to, Ms. Waddell's a neighbor that's always constantly dealing with Mr. Brunstein's problems.
Okay.
So she allows me to walk up her driveway to look over the fence. And
So it's
actually,
not-
that fence is missing the top right there,
So it's not something you see on a.
You can't see it from the street.
From the street, so you're not sure how chronic this problem is.
It's chronic, sir.
Is it bringing bugs or anything else? You know, like is it being left uncared for to where it is bringing a lot more mosquitoes or anything else in at all?
Yes, it's being uncared for. We're bringing in mosquitoes.
It's,
We put dumps in that pool. Periodically, we go by, we throw dumps into that pool.
We have to throw them because we can't trespass, so.
Right.
the Property next door.
just a reminder that it is a code violation to have an unkept pool.
Right.
So whether you have frogs jumping out of it or not, it's still a violation. So I just want to repeat that, because I do get into those conversations every once in a while from where I work, and frogs are a problem.
Again, I just want to clarify, is this the third violation, or the fourth violation, or the fifth violation?
This is going to be the second repeat.
So the fourth incident?
It's about the fourth incident, yes, sir.
Okay. Just for clarification, thank you.
You,
No, I was just wondering that you had a comment.
thanks. Okay, any other questions? There being none, I call for a motion.
I'll see if we can't handle this for you.
All right.
In case number 19-1924, I move that the city has proven by a greater weight of the evidence the following violations of the city, following repeat violations of the City of Temple Terrace Code exist on the property located at 418 Ferncliff Avenue, and violating of section 12-901 pools duty to maintain. The motion is based on the sworn testimony of this board, has received from Code Enforcement Officer Jose Silva, along with any other evidence, including photos, affidavits, and a notice of violation, all of which is received and entered as part of the record of this hearing. I further move that the respondents be found as to be a repeat violator as defined by City Code Section 1-63, because the respondent has been found to have violated the same provision of the code within the previous, over and over again, within the previous 5 years, regardless of the property address. I further move that a daily fine be assessed for the repeat violations from the time of the notice of the repeat violation until the time of the repeat violations are corrected. Upon consideration of the following factors: the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator, I move that the fine be $200 per day.
A second.
Okay.
He was going to ask something.
No, I was going to wait till the second came. I jumped the gun.
Motion second by Mr. Hubert. You have a
Just a
discussion?
point of clarity, can we not assess I believe we can assess a
Daily.
fine plus the daily occurrence on that, if I'm not mistaken.
Your lump sum.
We can assess a lump sum effective now and have the reoccurring daily fine run.
That's
I don't believe that to be the case. It's a repeat violation. What it is the fine would run from the date of the notice. You don't give a compliance date. The date of the notice would, is when the fine would run until the time that it's corrected. The amount of the fine is also raised because, the daily fine, the cap, can be raised because it's a repeat violation. If you were to direct the department to take some sort of action, then that amount, you could add that amount on, but it looks like that's not been done. So there is only the repeat daily violation.
And I think that accomplishes what you're talking about, because we can do it from the date of the violation, which is, what, May
The notice.
2nd, or the notice, whatever, what's the date of the notice?
Notice was 4th. It was done before.
Yeah, it's,
So-
point of
so-
clarity,
so-
can we pass this to the city attorney just to clarify, because that verbiage is not, I'm perceiving that verbiage different from what I was just advised by this, our attorney.
Well, I think it accomplished what you're asking.
No, I want to assess a fine plus your $200 a day.
Well,
For the 59 days.
Well, that's what he says with a notice of violation, so we would essentially, leaving here today with 200 times 59 days, and then it continues at $200 a day thereafter.
Right, because previously you had a $750 lump sum fine for the days that
Right.
he was
Out
out of
for
compliance
for the last
before.
one,
I
which
believe
he
on
probably, which he probably hasn't paid.
on repeat violations, I was,
Okay, Ms. Barney, so-
Assuming you did the math right, yeah.
Yeah, Suna did it right,
Yeah.
yeah.
In essence, it's the same thing. What this did is it did $750 against the violator for the days that the repeat violation existed prior to the date of the hearing. Then it started a $50 a day violation from the date of the hearing on. It's in essence the same thing, except we're doing it the way the code says, which is you assess the code the fine from the day that the notice went out. So it's in essence the same thing. You're not doing a lump. You'll be doing a daily fine from the day of the notice until the time it's corrected.
So
we
is
got-
that, did I misinterpret the verbiage that's typed there?
Yeah, what they did is instead of, and what they probably did was $50 a day from the notice to the date of the hearing was $750. I don't know how they came about $750. They did a lump sum from the date of the notice to the hearing. It says,
Right, yeah.
and was found guilty of a repeat violation. The board assessed a lump sum fine of $750 against the respondent for the days that the repeat violation existed prior to the date of the hearing. And then in addition, they had a $50 a day starting from the date of the hearing on. It's the same thing, only you're doing it as a
Gotcha.
running
So-
fine from the date of the
yes,
notice.
So,
rather
as
than a
soon as
lump
we
sum.
say yay, there's $11,800 fine.
I got you there. Now, but just moving forward, since we're on this topic and it's a point where, what if we wanted to assess $250 for the days it was out of compliance, and then the running fine runs $200 from the date of the hearing? Are we in our purview per this code to do that? To assess a higher fine for the days it was out of compliance, for those 59 days? And I don't know when we'd have time to discuss it again, but this,
No,
we
that's
have
a
these
good point.
cases.
It's a
We
good
have these
point.
cases.
the valid point, just a reminder, this property has over $180,000 lien already
Already on it, yeah.
on this property. So I understand the dialogue is good, and this is how we learn, but I
Yeah.
don't think we should knock ourselves out on this particular,
Is it occupied?
it's occupied and it's homesteaded, so.
So, and
The code really contemplates that you issue a daily fine that is consistent from the date when it's a repeat violation, from the date of the notice until the time that it's corrected.
I'll put a hypothetical. What if we charged $50 a day, since that's what the fine was before, for the 59 days it was out of compliance, and then $200 a day running from now? Is that, I'm just saying, would that be something that would be viable for us to do? Not saying that's what the motion is, but if we decided to do that.
It would be my recommendation not to do that. It would be
Okay.
my recommendation to follow the consistent daily fine from the date of the notice.
That's perfect. Those are the things that, coming up, if we have them in the
That's fine.
future, we won't waste time
No,
on.
no, that's good. Good dialogue.
Cool. Any further discussion? Call for a vote. All in favor, aye.
Aye.
Opposed, nay. No nays.
Next case will be case number 192274, City versus Twam and Nafis Group LLC for property located at 12107 North 53rd Street. Case is before the board based on alleged violation of Section 828A1, permits application required. Case will be prosecuted this evening by Officer Lori Smith. City is evidence that the notice of violation and notice of hearing were properly served.
Good evening, board members. Lori Smith, Code Compliance Officer. This case originated proactively on April the 29th, 2019. My inspection revealed the side yard had 11 fence panels installed without a permit. At that time, I left a door hanger with a compliance date of the 8th of May, 2019. My inspection on May the 14th, 2019 found no change, so a notice of violation was prepared with the compliance date of the 21st of May, 2019. No one was at home, so I posted the notice at the front door, and I requested copies be mailed certified in first-class mail. I also requested a copy be posted at City Hall for the 10-day requirement. My inspection on May 21st, 2019 revealed no change. At this time, I would like to submit photographic evidence of the violation taken by me on May 14th, 2019. Pictures showing the notice letter posted at the front door and the fence panels installed in the side yard.
Without objection, the evidence will be admitted into the record. Was this fence a replacement fence or a total new fence?
No, sir, actually, they put up a fence. It wasn't brand spanking new, it was kind of like used fence, and they put it up. And then they had plans of maybe installing a nicer fence, which you'll see in the second picture of some new fence, which they were going to do that, and they were possibly going to pull the permit until Amir, in addition to pulling the permit, sir, was requiring a survey to be conducted.
Right.
So they did not want to do that, and they took the fence panels down. As of today's date, the fence panels have been removed, and the site is now in compliance. And at this time, I'd like to submit an affidavit of compliance. I'm just looking for a finding, sir.
Without objection, the evidence will be admitted into the record.
Thank you. Did have one question. 'Cause I wanted to clarify your comment. I think what he was asking was not whether or not the fence was new or used, but was there a fence there before?
No, sir, there wasn't.
Okay, so this would have been all new fence.
Yes, sir.
Okay.
Well, not brand spanking new fence, but.
Well, it would have been
Yes, sir.
new to the site.
Yes, sir, absolutely.
Okay. But it is currently in compliance?
Yes, sir, it is.
Okay, awesome.
Any other questions? There being none, call for a motion.
Since I was late. It's not a punishment.
Punishment.
You win.
I win, huh? I must say, I like the new format here. I just gotta get used to it. In case number 19-2274, I move that the city has proven by greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 12107 North 53rd Street and was in violation of Section 8-28 subsection A subsection 1 of the code. The motion is based on a sworn testimony this board has received from the Code Enforcement Officer Lori Smith, along with the other evidence and including photos, affidavits, and the notice of violation, all which were received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Do I have a second?
I second.
Second, Mr. Westphal.
Yeah.
Any discussion? All in favor?
Aye.
Opposed? Nay? No nays. Next case, please.
Next case. So we will skip on down to the case number 192802, City versus Twam and Nafis Group LLC for property located at 12107 North 53rd Street. Case is before the board based on alleged violation of Section 10(3)B sanitation grass weeds. Case will be prosecuted this evening by Officer Lori Smith. City is evidence that the notice of violation and notice of hearing were properly served.
Good evening again, board members. Lori Smith, Code Compliance Officer. This case originated proactively May the 22nd, 2019. My inspection revealed overgrown grass in the front and side yard. At that time, I left a door hanger with the compliance date of the 27th of May, 2019. My inspection on June the 7th, 2019 revealed no change. Therefore, a notice of violation was prepared with the compliance date of June 17th, June 17th, 2019. No one was at home, so I posted the notice at the front door, and I also requested copies be mailed certified in first-class mail. I also requested a copy be posted at City Hall for the 10-day requirement. My inspection on the 19th of June, 2019 revealed no change. At this time, I would like to submit photographic evidence of the violations taken by me June the 7th, 2019. I have 3 photos, one showing the notice letter posted at the front door, side yard grass overgrown, and the front yard grass overgrown.
Without objection, the evidence will be admitted into the record.
Thank you.
As of today's date, the site is now in compliance. At this time, I'd like to submit an affidavit of compliance. I'm just looking for a finding.
Without objection, the evidence will be admitted into the record. Thank you.
Thank you.
Any questions? There being none, call for a motion.
I'll go ahead and take it again. Same property.
Maybe we can get the chief to bring in some of those Slurpee coupons.
There you go. You know my language. Okay, in case number 19-2802, I move that the city has proven by a greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 12107 North 53rd Street. Violation of City Code Section 10-3 subsection B. The motion is based on the sworn testimony this board has received from the Code Enforcement Officer, Lori Smith, along with any other evidence, including the photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine opposed because the violations were brought into compliance prior to the date of this hearing.
Motion.
Second.
Second by Mr. Snelling. Any discussion? There
No.
being none, call for the vote. All in favor?
Aye.
It was a tie.
Did we vote? All right.
Okay.
Opposed, no nays.
Case number 192596, City versus Remessa Realty Group LLC for property located at 5207 Blaine Drive. Case is before the board based on alleged violation of Section 12861E6, fences appearance. Case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated proactively by me on May 13th, 2019. My inspection on that date revealed a wooden privacy fence in disrepair. I left a door hanger with a reinspection date of May 21st, 2019. After having phone contact with the tenant regarding another violation, I provided a time extension for compliance to May 28th, 2019. My inspection on May 28th showed no change for the fence violation, so a notice of violation was prepared on May 29th with a compliance date of June 13th. I posted the notice on site, and the notice was also posted at City Hall, and copies were mailed, both certified and regular mail, to the address of the record of owner, or the owner of record. My reinspection on June 17th revealed the site was not in compliance. A notice of hearing was prepared on June 18th, and the case was scheduled for the July Municipal Code Board meeting. I have had contact from the property owner's representative, who called yesterday and is out of state, and I explained what would occur, and he stated he expected the site to be in compliance within 30 days. I was also copied this morning on an email from the representative to his maintenance service asking them to inspect and repair the site. At this time, I would like to submit photographic evidence of the site taken by me on May 30th and June 21st, 2019.
Without objection, the evidence will be admitted into the record.
Thank you.
Exhibit number 1 shows the posting of the notice of violation, and exhibit number 2 shows the wooden privacy fence in disrepair. At this time, the site is not in compliance, and I am requesting a ruling.
Okay. Any questions for Mr. Allen?
Do you anticipate it becoming into compliance by our next meeting?
Yes, sir, I do. I had a case with this site roughly a year ago, and once the gentleman received the notice of violation out of state, he got people to take care of the issue. So I think that due to our conversation and them emailing me or copying me on the email that he had already started getting something going with it, that I do expect it to be in compliance.
Good. I'm well covered here. Any other questions? There being none, call for a motion. Thank you, Mr. Allen.
I'll take this one. Unless you're jumping.
Jump.
Okay.
Go.
In case number 19-2596, I move that the city has proven by the greater weight of the evidence that the following violations of the City of Temple Terrace Code exist on the property located at 5207 Blaine Drive. Violation of Code Section 12-861, subsection E, subsection 6, fences appearance. This motion is based on the sworn testimony this board has received from Code Enforcement Officer Doug Allen, along with any other evidence, including photos, affidavits, and a notice of violations, all of which is received and entered as part of the record of this hearing. I further move that said violation be corrected on or before the date of our next meeting, August 14th, 2019. If the respondent does not comply with this order on or before that date, they are ordered to pay a fine for each and every day that the violation continues past the date set for compliance. Upon consideration of the following factors, the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator, I move that the fine be $50 per day.
Second.
Second by Mr. Napke. Any discussion? There being none, call for vote. All in favor?
Aye.
Opposed? Nay? No nays.
The next case will be case number 192629, City versus Sylvia Jackson, for property located at 8203 Hardy Place. Cases before the board based on alleged violation of Section 12860 inoperative vehicles outdoor storage equipment. Case will be prosecuted this evening by Officer Jose Silva. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening again, board members. Jose Silva, Code Compliance Officer. This case originated proactively on May 14th, 2019. My inspection at the time noted a vehicle in the driveway of the residence on blocks, missing the front driver's tire and axle. This time I left the door hanger with a compliance date of May 17th, 2019. My inspection on May 21st, 2019 found no change, so I completed a notice of violation with a compliance date of May 31st, 2019. No one was at the residence, so I posted notice at the front door of the residence as well as City Hall. Also mailed copies, both certified and regular mail, to the address of the registered owner. I inspected the property on June 1st and June 13th and noted the vehicle was still in the same condition on blocks in the driveway of the residence. This time I have 2 photographs I'd like to submit. Exhibit number 1 is going to be the notice posted at the front door, and exhibit number 2 is going to be the picture of the inoperative vehicle on blocks on June 13th, 2019.
Without objection, the evidence will be admitted into the record.
Thank you.
As of this morning, the residence is in compliance. The vehicle is gone from the property. I would like to submit an affidavit of compliance.
Without objection, the evidence will be admitted into the record.
Thank you.
Any questions?
All we're asking for is a finding.
Thank you. There being no questions, I call for a motion.
I'll go.
Mr. Napke?
Yay.
Hey, now be nice. In case number 192629, I move that the city is proven by a greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 8203 Hardy Place. Violation Section 12-860, inoperative vehicles and outdoor storage equipment. The motion is based upon the sworn testimony this board has received from the Code Enforcement Officer, Jose Silva, along with any other evidence, including photographs, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this meeting.
Second.
Second by Mr. Polardich. Any discussion? There being none, call for a vote. All in favor?
Aye.
Opposed? Nay? No nays.
Next case, case number 192644, City versus Bradley Moore for the property located at 9814 North 53rd Street. Case is before the board based on alleged violation of Section 10(3)B sanitation grass weeds. Case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening again, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated proactively by me on May 15th, 2019. My inspection on that date revealed overgrown conditions. I left a door hanger with a reinspection date of May 20th, 2019. My inspection on May 27th showed no change, so a notice of violation was prepared on May 29th with a compliance date of June 5th. I posted the notice on site. The notice was also posted at City Hall, and copies were mailed, both certified and regular mail, to the address of the owner of record. My reinspection on June 6th revealed the site was not in compliance. A notice of hearing was prepared on June 12th, and the case was scheduled for the July Municipal Code Board meeting. I have had contact from the property owner's representative, who contacted the tenant, making them aware of their responsibility for maintenance of the site. This time, I would like to submit photographic evidence of the site taken by me on May 30th and June 24th, 2019.
Without objection, the evidence will be admitted into the record.
Thank you.
Exhibit number 1 shows the posting of the notice of violation, and exhibit number 2 shows the overgrown conditions. At this time, the site is in compliance, and I'd like to submit an affidavit of compliance, and I'm requesting a finding.
Without objection, the evidence will be admitted into the record.
Thank you.
Are there any questions, Mr. Allen? There being none, call for a motion.
I'll make it.
Mr.
In case number 19-2644, I move that the city has proven by the greater weight of the evidence the following violations of the City of Temple Terrace City Code exist on the property located at 9814 North 53rd Street. violation of Code Section 10-3 subsection B. The motion is based on the sworn testimony this board has received from Code Enforcement Officer Doug Allen, along with other evidence including photos, affidavits, and a notice of violations, all of which is received and entered as part of the record of this hearing. I further moves that there were no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second by Mr. Napke. Any discussion? There being none, call for a vote. All in favor?
Aye.
Opposed? Nay? No nays.
Okay, unfinished business. Case number 190924, City versus James B. Burns for property located at 602 Courtney Drive. An affidavit of noncompliance for Section 81022 and 81021 was submitted by Officer Silva dated June 13th, 2019. Case number 191124, City versus Dabarash Santiago for property located at 7720 Gulf Court. Deadline for compliance is tonight at midnight. Case number 191241, City versus Mondido for property located at 8750 Morrison Oaks Drive. Affidavit of non-compliance for Section 103B was submitted by Officer Allen dated June 14th, 2019. And then on to other board action, the liens list review for the active accruing cases. I have affidavits of continuing noncompliance for case number 050557B, City versus Jeffrey L. Rhodes and Vernica L. Rhodes, 708 Grand Circle. Case number 80292, City versus Christopher B. York, 7604 Leon Avenue. Case number 152510, City versus Coyley Berry Jr., 10014 North 52nd Street. Case number 160491, City versus Richard D. Warren and Deborah L. Warren, 108 Mission Hills Avenue. Case number 162397, City versus Dudley A. Black, 9408 Hidden Ridge Place. Case number 172613, City versus Dudley A. Black, 9408 Hidden Ridge Place. Case number 172746, City versus James Stevens Johnson and Glenda Johnson, 104 Holland Avenue. Case number 172786, City versus Anthony D. and Marcina L. Bobo for 7501 Okeechobee Court. Case number 183885, City versus Diplomat Property Manager LLC for 107 South Greenfield Avenue. Case number 190054, City versus Safe Haven Property Investors LLC for 314 Springdale Place.
Thank you. Director Barone.
I have nothing to add.
Ms. Shoshone. Okay. I have nothing to add either, but I want to thank you for getting the cases into compliance that came into compliance tonight. Mr. Lloyd.
You were addressed the comments about the length and all that from the last, the comments from the Skype meeting.
No.
We're not going to address that?
No.
Okay.
So call for a motion to adjourn.
So moved.
Second.
We are adjourned. Thank you.
Thank you.
Thank you, guys. Thank you all.